appeal in the matter of BDW Trading Ltd and AECOM Infrastructure and Environment UK Limited.
Ms. Parkin, good afternoon. A couple of things before we get into it. The first is that you can take it that we have read the papers and have a lively appreciation of the issues that arise. Arising out of that, the second point, I'm not sure where the day and a half came from. I don't think it was me, because I don't usually overestimate, but the day and a half is a gross overestimate. However, we do accept that we can't expect you to finish it this afternoon, but we certainly do expect it to be finished absolutely no later than lunchtime tomorrow, and preferably before.
I'm obliged for those observations, my lord. I think I know the day and a half came from the parties. It came from the parties off the back of there being 2 very long days before His Honour Judge Kramer, in which a number of the authorities were explored, and essentially we're back to the beginning. Everything is as it was before His Honour Judge Kramer is now before your lordships.
Yeah, but possibly unlike Judge Kramer, we've had the opportunity to do pre-reading, and you have the intellect of both my lord and my lady, and therefore it may be a different ball game.
I'm obliged, my lord. If I perhaps start, and if I'll try to sort of put a mental red line through the bits that I'd intended to say, but if at any time your lordship considers that he's already on top of, or your ladyship or your lordship considers they're already on top of what it is I'm about to say, you'll no doubt give me the usual encouragement just to get on with things. My lords, my lady, as you know, this is an appeal on behalf of the Cameron Taylor defendants, Cameron Taylor Consulting, the 3rd defendant, and Cameron Taylor 1, the 4th defendant, and it's appeal from the order of His Honour Judge Kramer, made on the 19th of October. You'll have seen that order in the core bundle, tab 6, page 56. That order was made after an extremely lengthy extempore judgment, which you will also have seen at the tab 7 of the core bundle, by which he dismissed an application by CTC D3 to disallow amendments made to the claim form by the claimant. And that application was dated the 23rd of April and is in the supplementary bundle at tab 3A. And he allowed an application by my learned friend's clients, BDW, to substitute D4, Cameron Taylor 1, for D3, Cameron Taylor Consulting. That application was made on the 9th of June 2020. Can be seen in the supplementary bundle tab 5A, with the relevant evidence served in relation to it. Permission, as your lordship knows, was given by you, my lord, on the 4th of February. That's at tab 16 of the core bundle, and it concerns this appeal the effect of various amendments made to a claim form both before and after it was served. There are essentially 2 grounds of appeal. Ground 1 relates to my client's application to dismiss or set aside the amendments to the claim form made by BDW. And my lords, my lady, if you could perhaps turn to tab 2 of the core bundle, in which the grounds of appeal are there set out. Your lordships, my lady, will note that that is an appeal which ground 1 of which concerns the question of whether or not it was reasonably arguable that limitation had expired at the point at which the amendments to add a new party and a new claim were made. And as I know members of the court will have appreciated, this wasn't just a new claim, by which I mean a new claim arising out of the same development. It was a new claim concerning an entirely different development, a development in West London, where historically what had been raised was a development designed by an entirely different entity in East London. So that's
And the
ground
judge,
one.
I mean, I appreciate it arises sort of by a bit of a side ring, but the judge expressly accepts at 35 that this is not a same facts and matters dispute.
He does, my lord.
And says, I think he says clearly not, because Feltham is a completely different development
Absolutely, my
from
lord.
Cityscape. So this isn't same or similar facts and
No, my
matters.
lord.
I gather I've got that next week. But this week it's on the, what you say is the test of reasonably arguable, and then whether you say you meet that test.
Absolutely, my lord. And the test, as your lordship will have appreciated, arises both in relation to the application my clients made and the application my learned friends' clients made. And the reason for that is that limitation is a feature both of CPR Part 17 and of CPR Part 19.5. And if it's convenient, my lord, if we could just take the white book and just see how those limitation there appears. Starting with Part 17 at page 684. Amendments to statements of case after the end of a relevant limitation period. This rule applies where A party applies to amend his statement of case in one of the ways mentioned in this rule, and B, a period of limitation has expired under 1, the Limitation Act 1980, yep. And the period of limitation with which we are concerned here, my lord and my lady, is section 14B of the Limitation Act, which is the long stop, which we'll come to look at in a moment.
The 15 years.
15 years from the date upon which the causative act of negligence occurred. And then if one turns over to look at Rule 19.5, which one will find at page 711 of the White Book, special provisions about adding or substituting parties at the end of a limitation period. My lords, my lady, this applies, 19.5 applies both in relation to my application, in which there was an application to add CTC, and in relation to Mr. Hargreaves' client's application, in which there's an application to substitute CTO for CTC. And limitation arises twice in 19.5. One sees it for the first time at 19.5.1. This rule applies to a change of parties at the end of a period of limitation under the Limitation Act 1980. Now, importantly, in making the application that it did on the 9th of June 2020, BDW therefore accepted that at that point in time, a period of limitation, namely a section 14B period of limitation, had expired at the point it made that application.
9th of June.
9th of June 2020. So that's when the rule is engaged, when limitation has expired. 19.52 prescribes the circumstances in which the court can act, and it says that the court may add or substitute a party only if A, the relevant limitation period, that's section 14B again, was current when the proceedings were started, and for these purposes that's the 6th of March 2020, and B, the additional substitution is necessary. And as the court knows, the definition of what is necessary is prescribed by Rule 3. And the sub-rule with which we're concerned today is Rule 3A. The additional substitution of a party is necessary only if the court is satisfied that A, the new party is to be substituted for a party who was named in the claim form in mistake for the new party, and we'll come on to look at what that means, what the authorities said that means later on this afternoon.
And that part, is that relevant just to the application to substitute?
It's relevant to both applications, my lord.
So you say 19.3 is also relevant to both applications?
Yes, my lord.
Okay. Because the first part is addition and the second part is substitution.
Absolutely, my lord. So perhaps it's easiest to see how it works by reference to what actually happened to the claim forms. If the court would be so good as to turn up to tab 9 of the core bundle.
Yep.
One finds there the original claim form with the date stamp at the top right of the 6th of March 2020. The defendants only one there named, AECOM Infrastructure and Environment.
And it's agreed that they are no longer a defendant.
They are no longer a defendant. That is the effect of Judge Kramer's order of the 19th of October.
Well, I thought he was recording that.
He was recording effectively the concession which my learned friend had to make.
Yeah, so it's not AECOM.
It's not AECOM, and we'll come to look in a few moments as to why AECOM was first joined.
And the claim is this is the claim in relation to Capital East.
That's Capital East.
Yeah.
And it's a claim for damages for breach of contract and or breach of duty in respect of the design, consultancy or other obligations or services. And then paragraph 2, the important plea here, the defendant had design responsibility for the development. Due to the errors in the defendant's design and or breaches of contract and or breaches of duty on the part of the defendant, the development has exhibited serious defects, including without limitation, instances of under-reinforcement and overstressing. Now, I place some emphasis on the instances of under-reinforcement. Effectively, as I know Lord Justice Coulson knows, that means there wasn't enough steel placed in the slabs at the time of construction. So that's claim 1. And then over the page one sees the further claims. Defendant's breaches, this is paragraph 4 now, defendant's breaches of contract or breaches of duty place the claimant in breach of contract and or in breach of obligations owed to purchasers. Then there's a plea that effectively we're in breach of the Defective Premises Act or caused damage to other property. And then at 7, a plea that we are liable for a contribution or an indemnity under the Civil Liability Contribution Act 1978. Just for the court's note, there is in fact no claim for a contribution made in these proceedings at all. So that's the original claim form. At tab 10, one sees the amendments made
17th of March.
on the 17th of March.
Yeah.
And one sees immediately there the addition of 2 new parties, URS and Cameron Taylor Consulting.
And the position in relation to URS is that they are a live defendant not taking these points?
They are a live defendant not taking these points.
And are they the defendant responsible for Freeman's Meadow?
They are, my lord.
Right, so we don't need to trouble ourselves with either URS or Freeman's Meadow.
You don't, my lord, or indeed Capital East.
Yeah.
All your lordships and my lady are concerned with are
Feltham and
Feltham
CTC.
and the CT defendants, if
Yeah.
I can call them that.
Yep.
But importantly, my lord, if I could draw your lordship's attention to page 91.
Mm-hmm.
The amendment here is to add an amendment of an and/or variety with which I know this court will be familiar, but which on this case leads to a degree of head scratching. In particular because, and as is clear from the evidence of Mr. Aggetti that we'll come to look at in a moment, at the point in time that this claim form was served, the claimant was not sure, in particular, which party was responsible, was the contracting party for Capital East. Hence the reason one sees first defendants and or second defendants and or third defendants. So one sees all of the defendants and there is no delineation there between them as to who is responsible for which. And one sees that again all the way through this amended claim form. One can see it again in paragraph 2. So the defendant has been struck out, and then it says first defendant and or second defendant and or third defendant had design responsibility for the developments. Now, and then one goes on and one sees exactly the same amendment carried all the way through the claim form. Now, of course, as the court will appreciate, the significance of all of this is that these developments were designed and constructed a very long time ago indeed. And in particular were designed by a series of companies who at the point in time that the design was carried out had no connection with each other at all.
That's to say AECOM, URS and CTC.
Absolutely, my lord. And essentially what happened, and it's set out in the extract of Mr. Williams' second witness statements in the supplemental bundle, but essentially what happened is it's one of those corporate amalgamations with which we've become so familiar, where the smaller is gobbled up by the medium size and then the medium size is gobbled up by the bigger. So effectively, Cameron Taylor was gobbled up by an organisation known as Scott Wilson, who in turn was acquired by URS, who in turn in 2014 was acquired by AECOM.
Yeah.
And so today it is that all of these consulting engineers sit under the umbrella of AECOM,
Yeah.
but at the time they didn't.
At the time of the work. Yeah.
Absolutely. At the time the contracts were concluded and the services were provided.
Yeah.
And then if one just turns on to tab 11, one sees the final amendment made the next day on the 18th of March.
And the relevant amendment is the deletion of
It's
K1
deletion
and
of
Q.
K1 and Q in relation to Feltham.
and effectively having the whole
extension,
development.
Absolutely, to the whole
Yeah, understand that.
development, essentially.
Yeah.
Upon learning of what happened, my clients applied to set aside the amendments as they were entitled to do pursuant to Rule 17.2, which it's just worth turning up. If I can direct the court, please, to page 674 of the White Book.
Yeah.
If a party has amended his statement of case where permission of the court was not required, the court may disallow the amendments. And permission of the court was not required to make the amendments we've just looked at because the claim form had not been served on my clients at the point in time at which the amendments were made. And if one turns back to the previous page at 673, one sees at Rule 17.1.1 the power to make amendments to a statement of case any time before it's been served on any other party.
Yeah.
So the amendments we've just looked at were made purportedly pursuant to 17.1. When we discovered them, we made an application pursuant to 17.2, and we did so on the basis that if permission had been required from this court, it would have declined to grant permission. And the reason it would have declined to grant permission is that it would have been prevented from granting permission by virtue of the operation of Rules 17.4 and 19.5. And from my perspective, from the perspective of my clients and their application, the reason that permission would have been, in our respectful submission, refused is because it is arguable that a period of limitation had expired at the point in time at which the amendments were made. And the reason I put it that way, namely it is arguable that, is if your lordships turn on to page 685 of the White Book,
Could you give me the paragraph reference?
yes, it's 17.4.2, my lady.
Yep.
Resolving disputes as to whether a limitation period has expired. Where it's reasonably arguable that the relevant limitation period has expired before an amendment is made, the onus is on the applicant to show that the amendment falls within the provisions of 17.4 or 19.5. And then the second paragraph under that note, where there is a dispute as to whether or not a new claim sought to be raised by amendment is statute barred, the claimant must prove that 1, the defendant's limitation defence is not reasonably arguable, or 2, that in any case the amendment falls within the provisions of 17.4 or 19.5. If they cannot establish either 1 or 2, permission should be refused, leaving the claimant to bring fresh proceedings on the new claim. And the authority for that proposition is a case called Chandra and Brook North in the Court of Appeal, which the court will find in its bundle of authorities behind tab 6.
So this is Lord Justice Jackson,
It is, my lord.
and this is Lord Justice Jackson starting at 63.
My lord, yes.
That you've sidebarred 66 to 70, which I understand, but I think actually the relevant passage starts at 63 because
It does, my lord.
he is here translating, if you like, the Redpath Dorman Long case, which was under the old rules, but saying that the approach still applies under the new. But I think it would also be fair to say, having looked at the judgment in Redpath Dorman Long and the slightly dense passage from Lord Justice Glidewell, it would be fair to say that for the slower witted amongst us, mainly me, Lord Justice Jackson sets it out in rather clearer detail.
Indeed, my lord, and I suspect that is why it is cited in the White Book as
Yeah.
authority for the proposition.
But the starting point is Redpath Dorman Long.
It is, my lord.
Because I'm old enough to remember the excitement caused by that case and the way in which they dealt with limitations. So it is important that this is a principle that goes back nearly 30 years now.
Indeed, my lord, and should your lordship wish to revisit the excitement of his youth, he will find the judgment of Redpath Dorman Long right at the back of this authorities.
I have, and I looked at the passage that Lord Justice Jackson, for example, says, see the judgment of the court at 125 GH, and I've looked at that, and it is what it says, but you do need a slight wet towel on the head to get there. Whereas he, as I say, sets it out in ways that even I can understand. So anyway, those Welsh Development Agency, Redpath, Norman Long, and then Chandra, you rely on as setting out the way in which the court should approach these questions when there is an issue about limitation.
I do, my lord, and I should also add, and I'm sure Mr. Hargreaves will jump up if I've got this wrong, I don't think there's anything between the parties on that question.
Yeah.
So he accepts that if I can show it is arguable that limitation has expired, permission to amend should be refused, or in the case of my application, the amendments should be disallowed.
Can we just see what the implications of this are for this case? I'm afraid the excitement of Redpath Dorman Long passed me by at the time, but as I understand it, the claimants have done what these cases say they should have done, and they have issued new proceedings dated the 29th of June. So if you are right in knocking out these amendments so that you don't face a claim in respect of Feltham, what that means is that you knock out the drawings they rely on between 18th of March, or whenever it was, and the 29th of June. And looking at the table which you helpfully attached to your skeleton, that means that although you knock out some drawings, there would still be a claim, albeit based on only a limited number of drawings, in relation to block G, I and L. Is that right?
Not quite right,
Right.
my lord, for this reason. It's not just a question of drawings, it's a question of what the drawings have caused. So perhaps if
Well,
now...
that's Mr. Hargreaves' point, isn't it? He says it's not a question of limitation at all.
He
It's
does,
a question
because,
of liability and causation.
Absolutely. To which I say, if you look at section 14B, which is the limitation period, which is in issue before the court today, that's simply wrong, because section 14B is concerned inherently with causation of damage. And of course, the reason for that is, my lord, actions for claims in negligence are effectively actions which concern damage. Negligence is a tort in which damage is the key component. So it's not just a question of looking at dates on which drawings were issued. It's a question of understanding whether or not the causal significance has accrued at the relevant point in time. And we accept, my lord, that on the 29th of June, indeed, Mr. Hargreaves has issued a separate claim form in relation to Feltham. But as His Honour Judge Kramer made very clear in his judgment, because of the passage of time and the relevance of the time period, this is potentially a case in which every day might count, so to speak.
Well, it may be that nobody knows on,
absolutely.
either side when the relevant defective work was done.
Mm-hmm.
Assume it was defective.
Well, yeah. Although in some cases, I think we probably can at least hazard a guess from the drawings, which we'll come to look at in due course. Absolutely.
But assuming you're right for this purpose, and we're concerned with causation under 14B and getting all that, why is that? Why does that mean that my lord's summary is incorrect? Because there is a claim on the 29th of June, which they were entitled to bring for these purposes at any rate. Why isn't the position that if you're right, the effect is that they've lost between the 18th of March and the 29th of June 2005?
Mm-hmm. That is exactly, the question is the effect of what, so to speak. Is it the effect of drawings issued in that date, or is it, as I say it is, the causal consequence of the drawings, i.e. when the drawings were constructed?
But as my lord said, we may not know the answer to that. we're just concerned with the reasonable on your
Absolutely.
submission, the reasonable arguability of the case as put forward on reasonable arguability of your defence to the case put forward on the 17th, 18th March.
Yes,
we're not concerned. We're not concerned with an application to strike out or whatever the proceeding started on the 29th of June.
If it's reasonably arguable, I say, if it's reasonably arguable that the act of negligence, which is causative of the damage for which damages are claimed, occurred before 17th or 18th of March, then Mr. Hargreaves' amendments to his claim form should be disallowed.
Yeah.
And he should be held to his 29th of June backup claim form.
Right.
The reason that I put it in the terms that I do, my lord, is perhaps it's worth at this point picking up section 14B of the Limitation Act, which the court will find behind tab 2 of its bundle of authorities.
I should say I remember the excitement of this too. To get round Pirelli, or arguably to get round Pirelli.
Your lordship,
The
has led a
depressing
very
thing about this
exciting
case
life
is it makes
indeed.
you realise how old you are. All right, so we're looking at 14B, yeah.
And your lordship will see the title, Overriding Time Limit for Negligent Actions Not Involving Personal Injury.
Yeah.
So that's our type of negligence. An action for damages for negligence shall not be brought after the expiration of 15 years from the date, or if more than one, from the last of the dates on which there occurred any act or omission which is alleged to constitute negligence and to which the damage in respect of which damages are claimed is alleged to be attributable in whole or in part. So it's not just there's a negligent act, it has to be a negligent act with causative consequences.
Yeah.
Which is why I said at the beginning, I have to establish nothing more and nothing less than it is reasonably arguable, as at the 17th or 18th of March 2020, 15 years had expired from the date or the last dates on which there was a causative act of negligence.
Yep.
What one might ask, does causative act of negligence mean in these circumstances? The Court of Appeal has helpfully already considered this matter in a case called Pearson and Charter Partnership Limited, which the court will find at tab 8 of its bundle of authorities.
Yeah.
A case I suspect which is also well known to Lord Justice Coulson. One can see at paragraph 1 that it was an appeal from His Honour Judge Thornton concerning a claim for negligent design of guttering for a warehouse. There were two issues, one about whether or not a previous flood effectively broke the chain of causation. And the second issue, which one sees at paragraph 3, the second issue raised by this appeal is whether if the damages to PEL's books was caused by a breach of duty of care owed to them by CPL, the negligent act or omission on the part of CPL that caused the damage occurred outside the 15-year limitation period imposed by section 14B of the Limitation Act 1980.
Yeah.
If one just turns on to paragraph 9 on the next page, one can see the allegation of negligence there, which was an issue, which was the failure to specify guttering with an appropriate capacity. And then, if the court would be so good as to turn to paragraph 47, which is about...
This is where they deal with the second issue.
Absolutely.
Yeah. And the argument, as I understand it, was whether the cause of action accrued at the time of the initial mistake or at some time thereafter.
Absolutely. Yes, my lord.
And the Court of Appeal said it was the later date when the negligent design was incorporated in the warehouse.
Absolutely, my lord. So just pausing at 47, one can see the way that the Court of Appeal put it in Pearson. PEL's claim will be time barred unless they can establish an act or omission that caused the damage in respect of which they claim that occurred on or after 7th of January 1989. So again, the element of, or the emphasis on the act which is causatively relevant, as my Lord Justice Coulson has just identified. And then the issue which starts at paragraph 52. Paragraph 52, the court summarises the first instance judgment. 53, the submissions made by Mr. Dennis, which was, this all happened very many years ago, and then Mr. Edelman saying it's not quite the correct analysis. There are later breaches as well. And 55, this is the key paragraph. We do not accept Mr. Dennis's submission that for limitation purposes the relevant act or omission on the part of CPL was their initial mistake. Section 14B of the Limitation Act requires the court to identify the latest date when CPL were responsible for a negligent act or omission to which PEL's damage can be attributed. The gravity system designed by CPL was not incorporated in the warehouse. Whether or not CPL showed a failure to exercise reasonable skill and care in adopting a design capacity of 75 millimetres for that system, and on the evidence we believe that they did, is not relevant. The relevant negligent act or omission was the act or omission that caused an inadequate drainage system to be incorporated in the building, and then they identify when they say that act was, and they say that fell within the limitation period. And so the claim was not statute barred. So
I noticed that the passing reference in 56 to a continuing duty, but that isn't a point that arises in this case.
there is no continuing duty alleged here, my lord, no.
I mean, it's not a concept which gets very much traction these days anyway.
No, my lord.
But we can park it because it doesn't arise here.
You can park it because it does not arise on the pleadings on this case, my lord, so you're not troubled with that either.
What is the position if it's not possible to establish what the relevant act of negligence was or when it occurred? I mean, the particulars of claim in this case are a bit light on specifying what it is that the defendants did wrong and when they did it. The only fact or action which is referred to as far as I can see, other than in very general terms, is issuing drawings.
Absolutely, my lord.
So what is the position if really we just don't know what the position is?
In my respectful submission, what the court is required to do in that case is look at the evidence which is before the court, and we'll do that in a minute. And the question that again you have to ask yourself is Ms. Parkin's case reasonably arguable? By which she means, is it reasonably arguable that the relevant drawings were incorporated into these buildings before the 17th or 18th of March 2005? I don't have to persuade you that I'm right, only that it is reasonably arguable.
Thank you, that's very helpful to know where you're going.
And maybe with that, it might be helpful if I try to be even more helpful and take your lordship to a drawing, so your lordship can see why I say it is reasonably arguable. Now, my lord, the court, I think, has got very small A4 drawings. We've taken the liberty of blowing them up a little bit. Simply because I can't read them.
Thank you.
Apologies, these don't seem to have been hole punched, but they are in the order. In the order with which your lordships have them in the bundle.
So let's just identify them in the bundle.
So they're in your supplementary bundle,
Yeah,
my lord.
because I have looked at them and looked at the revision boxes. That they are very small, but I have been highlighting where I could the issue for construction.
Yes, my lord.
So this
Tab
is
7.
This is tab 7B.
B, that's right, my lord.
Starting, the drawings themselves start at
Page 79.
79.
And
In fact, I'm just looking to see what page.
Is that pagination?
Yeah, we've got 78, which is the index, but I'm not sure the drawings themselves.
Oh, there is. It's
so
absolutely
it's right
tiny
at
at
the
the
top,
bottom right.
in the
Oh,
right
yeah.
top right-hand corner. The number is, even on the blown-up copies, almost impossible
Yeah,
to read.
bottom right with the drawings, it's sideways. I see. So what you've given us, is this right? Are copies of 79 to 95.
That's indeed right, my lord.
Okay.
And what these are they are a series of drawings which are said by my learned friend's clients to be negligently prepared. And as I understand it, these are the series of drawings which sit behind some of the allegations of negligence that the court will have seen set out in the particulars of claim.
Yeah.
And in particular, my lords, my lady, I'd like to draw your attention, please, to page 86, which is about halfway through this little bundle. And it's entitled Third Floor Plan.
Okay.
And it's in relation to block I of Feltham. And just for cross-referencing purposes, and it may perhaps be sensible if I could trouble the court also to just have open the particulars of claim, which are in the core bundle at tab 13.
So we're looking at this as an example of the point.
It's an example of
You're
the point that I'm going to make to you, which is I have a reasonably arguable case that section 14B limitation has expired as at the 17th or 18th of March 2020, because
Okay.
the causative act occurred before the 17th of
So
March.
we're looking at 86 and as an example, and you want us to compare
And also, my lord, the particulars of
pleadings.
claim, which are tab 13 of the bundle,
Yeah.
and page 120
Yeah.
therein.
Yeah. So we're talking about block I.
Yes, my lord. Perhaps if I could just maybe start at 118 so the court can get its bearings.
Yeah, these are the particulars starting at paragraph 45 sets out the particulars of the alleged defects in the structural defects in the design, block by block.
Absolutely, my
Yeah.
lord, yes. by the time we get to block I on
Yeah.
page 120, the first thing to note here, of course, is that there are no dates given in relation to any of the drawings here.
Yeah.
However, we are looking at a drawing, drawing 01, I004 Rev C5 at page 86 in the supplemental bundle, which relates to the third floor
Yeah.
and is the third floor plan. Now, doing the best I can, I think this is the drawing which refers to the allegations which one sees at 45.3.2 and possibly 45.3.3. Maybe taking 45.3.2 because that's an easier one to locate on the drawings. There may be excessive local strut and tie stresses in the transfer walls between level 1 and 3 at grid line 14, 15 and 16, and between levels 3 and 4 at grid line 6, 7 and 8. And if I could just do a bit of a sort of a point and demonstrate to the court, one sees 14, 15 and 16 at the bottom there, pink line, and then at the top there one sees 6, 7 and 8. So one can see the numbers hopefully on the drawings. Top left 6, 7 and 8, those are grid lines 6, 7 and 8, and then bottom towards the centre 14, 15 and 16. So the allegation here is about these transfer walls along these grid lines, and one can see the walls, if one follows the grid lines along, one can see where those walls are. For example, at 14, 15 and 16, if you just follow the line up the page, you can see the words RC wall under.
Yeah.
Let's then look at when this drawing was first produced. One can see from the bottom right it's got a date of February 2003, and the revision box, which is on the right halfway up, identifies a series of revisions. T1 to T3 revisions of the drawing which are sent out to the contractors to tender on, and then C1 upwards, construction issue.
Yeah.
Which for those members of the court who have not had the exciting life that Lord Justice Coulson and I have had, means these are the drawing revisions which are issued for construction. One can see there that the first construction issue is dated the 26th of November 2004, and then as one goes up there are a series of additional dates as revisions are made. Now,
And is this right? In the usual way, the revisions are in the clouds, and
Absolutely.
in these bigger, this is helpful because in the bigger versions of the drawings, the cloud is in red, so they're easier to spot. And on the face of it, there doesn't appear to be a cloud between 14 and 16, or between 6 and 8.
absolutely, my lord.
Yeah.
So effectively, all revisions of this drawing up to C5 are out of time. By which I mean were issued before March 2005. My Lord Justice Mill's absolutely right. I couldn't tell you, standing here, the date upon which this building was constructed, but I can tell you that the drawing was issued for construction on the 26th of November 2004, and the last revision of it was issued on the 29th of March 2005, But as Lord Justice Coulson has just identified, the changes instituted on the 29th of March 2005 have nothing whatsoever to do with the case made against my client. They're in an entirely separate part of the structure. So, in my respectful submission, what this drawing shows is that there is a good arguable case that the causative act of negligence occurred before the 17th of March 2005.
In fact, on this particular example, it's only the very last revision which, if it was causative, would be on time.
Absolutely, my lord, yes. Now, it might be said that I've chosen one which is really helpful to my case, and in one sense, of course, I have. As your lordships go through, your ladyship goes through this clutch of documents, you will see drawings which, some of which are clearly in time, some of which have dates which come right back to 2003 and have various issues all the way up to 2006 and beyond.
Well, if the, as you say, these are the same drawings as in, but we've got the smaller versions. On the smaller versions, I didn't do a final head count, but the majority of them have a date for construction issue before the 18th of March.
Absolutely, my lord.
I follow. I think it's reasonable to simply take one as an example, because we can look at the others, but I have looked at them.
Absolutely, and if and to the extent that there are drawings that have dates for construction issue, first dates for construction issue after the 17th or 18th of March, the difficulty for my learned friend is that when one comes to look at the claim for loss and damage in this pleading, it's impossible to separate it out.
Okay.
And you can see that if you've still got the pleadings open, my lords, my lady, one turns onto page 122. One sees the plea here at paragraph 48. By reason of Cameron Taylor's negligence, BDW has suffered loss and damage, and then one has to turn over all the way down to page 125. And at 125, one sees the claims for loss and damage made, which, as the court will appreciate by a quick skim through, are made on a development by development basis rather than a block by block basis.
Oh.
So that, in a nutshell, is why I say my case is reasonably arguable.
Yeah.
It's said against me that no, I've got this all wrong, because actually all that matters is the fact that Mr. Hargreaves' clients are relying on drawings which post-date the 17th and 18th of March, as to which I'm going to make 2 points. Firstly, that is absolutely not clear from the pleadings as they stand in relation to Feltham. if we go back, flick back in the pleading, starting again at page 118. One sees in relation to the blocks in which certain drawings are indeed specifically identified. So let's take block 1G at 45.1 at the bottom of 118 and going on to 119. One sees the plea there at 45.1.1. In relation to the transfer column at level 5, there is one column starting at the 5th floor supporting the 6th floor roof without any shear reinforcement in the slab, contravening the requirements of BS 8110. And then over the page, this defect was the result of inadequate reinforcement provided in Cameron Taylor's design drawings, including, and 2 drawings are identified in final revision in or around September 2005. So that is not a claim which is in any sense time limited.
No.
And again, if one goes to look at the particulars of negligence at page 121, one will struggle in the particulars of negligence section of this pleading to find any date limitations at all, or indeed any limitations to the drawings which we've just concerned ourselves.
No.
So that's point 1. The pleadings do not contain any limitation on time in relation to dates of drawing issue at all. Point 2 is that Mr. Hargreaves' answer is not an answer to section 14B at all. He says, I identify drawings with a later date and I take my chances on causation. That is not an answer to the question, does Miss Parkin have a reasonably arguable case on section 14B? Namely, that this action for negligence, for damages for negligence, should not be brought because the causative act occurred before March 2005.
Yeah.
On your first point, which was the statement in the pleadings which the judge relied on? Is that the one in the reply?
He does rely on the one in the reply, but the reply does not deal with Feltham Axiom, and I can show you the reply, my lord. May I do that via the defence, if you see what I mean?
Yes, by all means.
I
I just wanted to identify it.
Yes, absolutely, my lord.
Because you don't plead in the defence to Feltham.
No, we don't, my lord.
So therefore, by definition, the reply can't deal with it.
Absolutely.
What is the passage, as my lord has asked?
It is. I think Lord Justice Mayles is concerned with the reply, which is in the supplementary bundle, tab 6, and it's at page 59.
Yeah.
And you'll see immediately why I said, could we go to it via the defence? Because it starts by saying, as to paragraph 9.2, and the question is, well, what does paragraph 9.2 say? The defence itself is in the core bundle, and it is behind tab 14.
Yeah.
And firstly, one sees at page 128 the plea there that we're not pleading to the Cameron Taylor claim. 9.2 is a summary of the defence. 9.2 concerns Freeman's Meadow. Also, importantly, for the purposes of, just so that the court sees how it was pleaded out in relation to the other two cases, the more developed limitation defence is set out at page 157. And if the court were good enough to turn to paragraph 39.3.2. 3.2, the court will see the plea of section 14B, the nature of which we've been discussing this afternoon. Now, as I say, this is in relation to the two cases that you're not concerned with, so to speak.
Yeah. Hence
why it is the judge actually got it wrong when he said that the reply contained the pleaded concession. There is in Mr. Ajetti's second witness statement, which Lord Justice Males might have also had in mind, a similar plea or assertion at paragraph 4.7 at page, that's in the supplementary bundle, tab 7A, page 70. Accordingly, for the purposes of the particulars of the claim, BDW sought to identify the drawings issued by Cameron Taylor and the date on which those drawings were issued, and to pursue claims only insofar as relevant drawings were issued after the 18th of March 2005. In my respectful submission, that's not what the pleading says, for the reasons, well, I mean, we've been through the pleading and the court can read it for itself, but there is no date limitation in the pleading at all. BDW has since confirmed that insofar as drawings or revisions relating to any given defect were also issued on or prior to 18th of March, BDW does not pursue any claim in reliance on such drawings. BDW's reply, paragraph 5.3. But again, that relates only to the claims for Capital East and Freeman's Meadow.
It's pretty clear, isn't it, that even if they not quite got their reference right, because the reply was only responding to the defence didn't deal with Feltham, they were committing themselves to the line they would take if this amendment was allowed to stand.
Well, we can read what it is Mr. Ajetti says about the line that they're proposing to take. The point, my lord, is that for the purposes of this application, your lordships, my lady, is obliged to look at the pleadings in the form that they currently stand, because that's what my learned friend will be given permission for. And the pleadings as they currently stand, firstly, are not limited to drawings, and secondly, are not time limited. And even if they were, for the reasons that I've explained, the time limitation is not an answer to my section 14B argument. Now, if I am right about that, that's the end of the application, that is the end of the attempt to amend the claim form.
Yeah.
And the rest falls away.
When you say the rest, you mean the substitution?
Absolutely.
Because there isn't anybody to be substituted. Yeah.
And if for some reason my 17.2 application to disallow the amendments fails on another ground, my limitation argument is still good enough for the purposes of 19.5 to mean that the consideration of whether or not the substitution was necessary falls away as well. So just to rebase ourselves in 19.5 at 7.11 of the White Book.
This was your earlier point that it still applied, that the limitation point applies to both.
Absolutely,
So
my
that
Lord,
if
yes.
you fail on your first ground, but not on the limitation point, you say the limitation point rose back in, and you were just confirming that by reference to 19.5, which?
19.5 2, which is on, the rule starts at 7.11, 7.12.
Yeah, the current limitation.
Yeah, absolutely. So one sees again from 19.5.2 that both limbs there have to be satisfied. The argument that I've just made relates to 19.5.2a. If you're with me on that, we don't need to go into 19.5.2b. If you're not with me on that, the court will also have to consider 19.5.2b.
Yep.
Which is where, with the court's permission, I will turn next.
Yeah.
The question of, and I should at once say that 19.5.2b, we are concerned with substitution. So 19.5.2b arises on the application made by my learned friend to substitute CT1 for CTC.
Yeah.
And the just going to would it assist your lordships, my lady, to see the application, or are you
That's in the supplemental.
it's in the supplemental bundle at tab 5 at page 38. Actually, it probably is worth a look. Now, you'll see what happened here is that this is an application that Cameron-Taylor 1 is substituted for Cameron-Taylor Consulting in accordance with 19.5.2 or 19.2 for the reasons set out in the attached witness statement. Now, the importance of the 19.2 application fell away before His Honour Judge Kramer because my learned friend accepted that a period of limitation had expired as at the date this application notice was issued. So he was in the 19.5.2 territory. It's of some note, my lord, that if he had not made that concession, namely if he'd maintained the position that limitation had not expired in June 2020, he would have been forced back on the provisions of 19.2 to make the substitution application. And if one just takes a brief look at 19.2 at 7.06,
Yeah.
one sees at 19.22 the conditions, sorry, 19.24, the conditions that would have had to have been fulfilled in order for the substitution application to work there court may order a new party to be substituted for an existing one if the existing party's interest or liability had passed to the new party, well, that wasn't this case. It's desirable to substitute a new party so that the court can resolve the matters in dispute in the proceedings. Again, on the authorities, that wasn't this case either. So, if my learned friend had been left to the mercy of the court on an ordinary case, he would not have got permission to make the substitution that he now seeks the court's permission to make. Returning to 19.5, which is the realms in which we're operating, as the rules make clear, this is a notoriously difficult area in terms of the application of the test. The test itself being, in my respectful submission, relatively straightforward to enunciate. And the test, insofar as it relates to the modern rules, is to be found in a case called Adelson and Associated Newspapers, which is behind tab 4 in the authorities bundle.
Yeah.
Adelson attempted to resolve the slight impasse created by the authorities on substitution, which had arisen as a result of the new CPR rules in 2000. By way of summary, as I know the court will know, under the old rules, substitution was permitted in the circumstances prescribed by RSC Order 20, Rule 5, Paragraph 3. And when the new rules were promulgated, RSC Order 20 became sort of fragmented in the sense of part of the rule found itself parked in CPR Part 17 and part found itself parked in CPR 19.5. The wording in both being a little different. And what Adelson was concerned with was whether or not the old authorities on interpreting the test under RSC Order 20 Rule 5 were still relevant under the new rules. Essentially, if one starts at paragraph 1 of the judgment of the Chief Justice Lord Phillips, page 333, one sees there that it was an appeal from the first instance judge who had dealt with an application pursuant to the provisions of 19.52 and 3, dealing not with adding parties but with substituting parties. And then one sees, after the citation of the relevant provisions, the action was commenced within the 12-month limitation period that applies to defamation proceedings, but this period had elapsed before the application was made to join the additional claimants. And then over the page at 334, paragraph 3, one can see the basis upon which the judge rejected the application. And then at page 337 onwards, the court sets out the history of the rules, both from a statutory and rules-based approach. One sees there at page 16, Limitation Act 1980. The rules themselves at 338 are set out at pages 18 and paragraphs 18 and 19. And then on the top of 339, one sees the previous rules and their relevance, which goes through some of the history of the old Limitation Act and the old rules of the Supreme Court, and the cases which were decided under them. And that is a lengthy discussion there of the rules and the relevant authorities. And for these purposes, my lords, my lady, if one would turn on to 346, paragraph 43.
Yeah. I have to confess that was the paragraph I'd marked up originally.
I'm so sorry, my lord.
That was the paragraph I'd marked up originally, because that's where they get to.
Absolutely.
After that trawl through the
Yes.
old cases.
Absolutely. It's the equivalent of Lord Justice Jackson's summary in Chandra.
Yeah.
It's a neat summary, in my respectful submission, of what the old law established. At paragraph 44, the court notes that the new rules are slightly different in wording, and in particular between G and H. Nevertheless, section 35 in CPR 1953, in contrast to CPR 1743 and RSC 20 Rule 5, do not specify that the mistake must not be such as to cause any reasonable doubt as to the party intending to sue or be sued. Effectively noting what I explained a moment or two ago, namely the difference in wording between the rules. Then the court goes on to consider the post-CPR authorities, noting that the Court of Appeal got it wrong in Gregson and Channel 4, but that over the page at paragraph 48 onwards, other courts had more luck in their application of the proper test. And then at paragraph 55, which is on 349 of the bundle, one sees the drawing it all together, concluding section. What is it that one needs to establish for the purposes of an application to substitute under 1953A? And the court said this: it's clear from this language, that's the language of the rule itself, that the person who has made the mistake must be the person responsible, directly or through an agent, for the issue of the claim form. It is also clear that he must be in a position to demonstrate that, had the mistake not been made, the new party would have been named in the pleading. I'm going to call that the causation requirement. And then 56, so the first two requirements there, the Chief Justice derives from the rule itself. And then at 56 he says this: the nature of the mistake required by the rule is not spelt out. This court has held that the mistake must be as to the name of the party rather than as to the identity of the party, applying the generous test of this type of mistake laid down in the Sardinia Salsis. The working test suggested in Weston's case, inasmuch as it extends wider than Sardinia Salsis, should not be relied upon. And then 57, which is important, almost all the cases involve circumstances in which, one, there was a connection between the party whose name was used in the claim form and the party intending to sue or intended to be sued, and two, where the party intended to be sued or his agent was aware of the proceedings and of the mistake, so that no injustice was caused by the amendment. In the Smith-Kline case, however, Lord Justice Keane accepted that the Sardinia Salsis test could be satisfied where the correct defendant was unaware of the claim until the limitation period had expired. We agree with Lord Justice Keane's comment that, in such a case, the court will be likely to exercise its discretion against giving permission to make the amendment. So effectively, my lords and my lady, 3 tests laid down by Adelson. The person responsible for the mistake, the person making the mistake must be the person responsible for the issue of the claim form. He has to demonstrate that had the mistake not been made, the new party would have been named in the pleading, and the nature of the mistake has to be one of name and not identity. That latter test being one set out in the Sardinia Salsis. Now, much of the authority since Adelson has been concerned with the application of the Sardinia Salsis test, namely, is it a mistake about name or is it a mistake about identity? However, the other 2 parts of the rule are important, and in my respectful submission, the evidence adduced by the applicant must meet the requirements of the other 2 parts of the test set out in Adelson. Now, in a nutshell, our submissions are that Mr. Hargreaves' clients should not be allowed to substitute because on the evidence they have not demonstrated that but for naming consulting they would have named 1. That's point 1. And for that, we will look at Adelson in a little more detail because actually Adelson is concerned with the application of that rule. And I will also say that permission to substitute should be refused because on the evidence, Mr. Hargreaves' clients have failed to demonstrate that the mistake is as to name. Now, just while we're on the test part of things.
So that, sorry to interrupt you, that your 2 points here pick up what you say are propositions 2 and 3 from Adelson.
Absolutely, my lord, yes.
Okay. Yep.
And proposition 2, I'm saying, actually isn't considered by the courts very much. And the reason for that is that it's usually pretty obvious that if they hadn't named X, they would have named Y. And I'm going to explain to the court why in this case it's not so obvious. And the third limb, which is the sort of the case law test, if I can call it that, the Sardinia Salsis test, before we go to look at the evidence, I'm just going to take the court to one more authority to see the way in which that case law test has evolved over time.
This is name as opposed to identity.
Absolutely, yes,
Yeah,
exactly.
yeah.
And I mean, that's one of those, it's a bit like an elephant. It's sort of easier to say than it is to describe. Or, you know, essentially, it's easy to say it's got to be as to name and not as to identity. Actually, translating that into applying it to a situation in front of one is, in my respect for submission, rather more difficult.
Yeah.
At least certainly for me it is. I've been helped by the observations of Mr. Justice Leggett, as he then was, in the case of Insight and Kingston Smith, which the court will find behind tab 7 of the bundle.
Yeah.
Insight was a case in which the claimants had joined the, it was a claim for professional negligence, which is another reason why it's, in my respect for submission, a useful judgment for the court. And it was a claim against a firm of chartered accountants. You can see that from the head note. On the 11th of November, the claimants brought an action for damages against a firm of chartered accountants. The accountants had formerly practiced as a partnership, but became an LLP with effect from May 2006. The claims for breach of duty of care owed in contract and in tort allege that the accountants have been negligent in the course of acting as the claimant's auditor from 1999 to 2006. Almost all the allegedly negligent acts were committed by members of the firm before it became an LLP, with the result that the LLP could have no liability for those acts. However, the LLP was named as the defendant in the claim form by mistake. And then there was an application before Mr. Justice Leggett to substitute. Having reviewed the test, or the tests which he was obliged to apply, Lord Justice Leggett concluded that Adelson applying Sardinia Salsis was the way forward. And he sought to apply it to the facts of this case. And for these purposes, if the court could turn on to page 533. At paragraph 57, Mr. Justice Leggett puts the matter thus. In order to decide whether the claimant's mistake can be regarded as one of name rather than description, it is thus necessary to distinguish between the following two possible cases. The claimant sues the LLP in the mistaken belief that the LLP provided the services which are said to have been performed negligently, failing to recognise that the services were provided by the former partnership and not the LLP. And two, the claimant knows that the services were provided by the former partnership, but mistakenly believes that the LLP is legally liable for the negligence of the earlier firm. The court has the power to grant relief in case 1, but not in case 2. And then this important paragraph, paragraph 58, to determine into which category a particular case falls, it is necessary to consider the whole of the evidence which may serve to explain why the LLP and not the firm was named as the defendant in the claim form. Such evidence will of course include any explanation given by the person who was responsible for preparing the claim form, but any such explanation may well not be conclusive, not least because the person responsible for the mistake may have given no proper thought to the decision to name the LLP as the defendant, and may not consciously have followed either of the possible thought processes distinguished above. Any explanation given of the nature of the mistake may thus be an attempt to rationalise what was done in hindsight. For that reason, objective evidence is likely to be just as, if not more important, if particulars of claim were prepared when the claim was issued, or at any rate before the mistake was recognised, they may be the best source for inferring what the claimant intended. It is also potentially relevant to consider what was said in any correspondence which preceded the issue of the claim form and in subsequent correspondence, insofar as it sheds light on what the reason for naming the LLP, reason was for naming the LLP as the defendant. Now, just clearing a few things off the table there. Here, of course, we know that the particulars of claim were not prepared before the mistake was recognised. So one cannot use the particulars of claim as a guide to ascertaining what it was the claimant intended.
Because by the time the particulars of claim, it was CT1.
Absolutely, my lord, yes.
Yeah.
Secondly, there was no pre-action correspondence in relation to Feltham or any Cameron-Taylor defendant at all. So no light.
Well, I understand that, but I'm slightly troubled about getting too deep into pre-action correspondence, because there were obviously pre-action dealings and privilege has been claimed for them. And therefore, I mean, that's obviously somebody's right to claim privilege, but we therefore have to be careful.
I absolutely agree.
I certainly wouldn't want to be coming to any conclusions based on the absence of pre-action correspondence. I mean, the evidence will be the evidence, but the sort of the negative inference. If you claim privilege, it's a very blunt instrument, and I'm not coming to your rescue if you do.
I understand entirely what your lordship says. Perhaps if I can just show your lordship a sentence, and in Mr. Williams' evidence, and note simply that it is not contradicted in his witness statement served in support of Cameron Taylor's application. It's in a supplemental bundle.
Yeah. Williams 1.
Tab 3B.
Yeah. Paragraph.
Your lordship will just give me a moment. It's page 24 and it's paragraph 617. This part of the witness statement, as your lordship will recollect, deals with the standstill negotiations, and the final sentence of paragraph 617 says Barrett and Osborne Clark had never raised Feltham with us during the standstill discussions.
Yes.
And that is not.
And I can confess to you that I have written in green highlight pen, which I don't have here, so that's my proof that I didn't do it during the hearing, but did it before. I have written, how do we know it's all covered by claim for privilege?
I will put it another way. It is not said against me, well, you knew about all of this because we told you that we were making a claim against the contracting party, the party providing services in relation to Feltham. Feltham was effectively a bolt from the blue.
Okay, so
that's a minor point, my lord, and I have to say it's there as a, it's essentially I'm just clearing this out of the way so that in fact what the court can do is then focus on what, in my respectful submission, is the real meat of the matter.
Yeah.
Mr. Justice Leggett explaining the sort of approach that the court is required to adopt, which is effectively a careful scrutiny of the evidence. And when we go back to look at Adelson, we'll see that the court there doing exactly the same thing. Now, what I'd like to do for a moment is to just go back into to paragraph 57, in which Mr. Justice Leggett explains the test and translate it into this case so that the court can see the exercise with which it's concerned. So, I'm just going to read because I've written it down here. So, it's necessary to distinguish between one of the following two possible cases. One, BDW sues Consulting in the mistaken belief that Consulting provided the services which are said to have been performed negligently, failing to recognise that the services were provided by Bedford and not by Consulting.
Provided by whom?
Bedford. Sorry, one, I should say. That's very bad of me.
Yeah. I was just gonna-
Bedford became one. Sorry, one.
Oh, okay.
Right.
And not Consulting. So that's category one. If the evidence establishes category one, the court has the power to grant relief.
Yeah.
Category two,
Yeah.
BDW knows that the services were provided by one, but mistakenly believes that Consulting is legally liable for the negligence of one.
Yeah.
Now, in those circumstances, the court has no power to grant relief
Yeah.
because the mistake is one as to identity and not of name. Now, the reason why your lordships raised your eyes when I said Bedford is that CT1 was formerly known as Cameron Taylor Bedford.
Yeah.
And that will become important in a moment. So in my respectful submission, when one looks at the totality of the evidence, I say we're a category 2 case, or at the very least, the evidence does not establish that this is a category 1 case. And the onus is on my learned friend to adduce evidence which does so establish. Why do I say that BDW, the evidence shows that BDW knows that the services were provided by Bedford, but mistakenly believes that Consulting is legally liable for the negligence of Bedford? I say that, and I'm afraid to say we're going back to the drawings again. Because a number of these drawings, including in particular the one we were looking at a moment or two ago, page 86 of the supplementary bundle, say on their face that they were prepared by Cameron Taylor Bedford.
But they're not, they were never a defendant.
Well, they are now, they're one.
Well, yes, but they weren't a defendant. So
No.
how do we get from Cameron Taylor Bedford to Cameron Taylor 1 on the evidence as to mistake?
I'll show you in a minute.
Okay.
Bring oneself back to the test again. The test is services provided by Bedford but mistakenly believing that consulting is legally liable for those services.
Yeah.
Just looking at the drawings, which is the only contemporaneous evidence that your lordships, your ladyship has before them, one will struggle to find a reference to Cameron Taylor Consulting at all. There are, however, a number of references to Cameron Taylor Bedford. I'm just going to give you the page numbers. Page 81, page 86, page 87.
Well, I'm sure we can look at the drawings and see that a number of them say Cameron Taylor Bedford. Yeah.
Yeah. So the evidence from the drawings shows Bedford involved in the design of the work. We'll next ask ourselves the question, so how does consulting get to be added as the defendant to the claim form? And the answer to that question is set out in Mr. Ajetti's first witness statement, which is tab 5, section B. At paragraph 3.27 on page 47.
Yeah.
And I particularly like to focus attention on subparagraph B.
327.
3.27, my lady, at page 47.
B, yeah.
BDW's West London division populated a spreadsheet to assist PwC UK with its collation of information relevant to claims against AECOM companies. The spreadsheet produced by BDW's West London division has not been located in the time available prior to making this application. And I should say to the court that not only had it not been located by the 9th of June, it wasn't available before the court when it heard the application last October, and it hasn't been produced subsequently.
Yeah.
In respect to Feltham Axiom, I understand that the person at BDW's West London division populated the structural engineer section of the spreadsheet as Cameron Taylor Consulting Ltd. This information was then reproduced in information provided by PwC UK to Mr. Mullen, Pease Barrett's in-house counsel, who issued instructions to me on the basis of that information. And that is it.
So why do you say that shows it's a category 2 case?
I say, my lord, that the only primary evidence that the court has before it is the drawings. The drawings don't mention CT Consulting, but they do mention Bedford.
Mm-hmm.
If one were to identify from the drawings which party was providing the services, one would identify Bedford. But for some reason, BDW identified consulting. Now, I have no way of knowing, and neither does the court, why consulting was identified, what information was available to BDW to arrive at the identity of consulting, what even the column in the spreadsheet or the section in the spreadsheet entitled structural engineer even means.
Don't we know a little more than you're suggesting? Because in paragraph 327A, Mr. Rajetti says that his intention was to name the company which was engaged to provide design services, and he believed that to have been Cameron Taylor Consulting, because that's what the information was that was given to him. So to accept your submissions, that this is a category 2 case, wouldn't we have to say that the judge was not entitled to accept that evidence?
In my respect, well, it's not that it's not entitled to accept that evidence. The evidence in 327A is what that evidence is. In my respectful submission, though, when one gets to read A in combination with B, the answer is not so straightforward. It just isn't. How it is that consulting comes to be the firm or the organisation which is identified on the claim form is a matter of complete mystery. I mean, one can postulate all sorts of grounds upon which consulting might have been identified, but we're at that stage in the grounds and the realms of speculation.
Well, the judge does accept that evidence, doesn't he? That's why I put it in terms of we have to conclude he's not entitled to, because his conclusion at paragraph 92 seems to be clearly based on that evidence.
Absolutely.
And that's describing a category 1 case.
And one of the grounds of my appeal, my lord, is that he was wrong to do so.
Yes.
And in my respectful submission, when
So you do say that we would have to conclude, to allow your appeal on that ground, that he was not entitled to accept that evidence.
absolutely, my lord. Or well, sorry, he mischaracterised the whole of the evidence together. He ignored the evidence in B.
Do we see, either in the judgment or indeed in your skeleton argument, the weight placed on the reference to Bedford in the drawings, which you've just developed orally?
No, my lord, you don't, no.
Was it a point below?
It was a point below, my lord, yes, I'm pretty certain it was, yes.
Okay.
Because what we were doing below, my lord, was essentially testing the evidence, and the point that I was making below was that there is absolutely no evidence before a court as to why it was that consulting were identified as the contracting party. Now, the important point to bear in mind at this point is that what we do know is that they don't have the contract. They cannot locate the contract. So they are arriving at a description of a party based on a realm of information, the nature of which is entirely unexplained in this witness statement.
Well, it may be that it's my fault, and I'm perfectly prepared to accept that it is, but I mean, I just didn't see in your skeleton
No, you wouldn't have seen
reference to the drawings, and this is a category 2 case. And if that's not there, and if it wasn't there with that clarity below, I just wonder whether it's fair for you to say the judge got it wrong for the reasons he gave.
Well, my lord, it was argued below in the clearest terms that the evidence did not support the finding of the mistake that the judge found, and he effectively ignored. Let me just take my lord to the ground of appeal. And you're absolutely right to say it's not in my skeleton. It isn't in my skeleton. That's why your lordship doesn't see it.
That's a relief for me anyway, if not to you.
It's fair to say, my lord, it is essentially, as one comes to develop these submissions, and I find this area of law extraordinarily complicated to try to explain in a way in which is coherent and easily identifiable.
That does give rise to a related point that we have to be careful not to turn questions of substitution of parties into a state trial. I mean, this is supposed to be done at a relatively straightforward level at the interlocutory stage. Speaking for myself, I can't help thinking that we may be over-complicating what ought to be a fairly straightforward exercise.
Well, my lord, we'll see in a moment the way in which, for example, the exercise is undertaken in Adelson. But in my respectful submission, it is important that the court scrutinises the evidence with care. Because, and the reason for this, my lord, is because only certain sorts of mistake are mistakes which will allow the court to exercise its discretion.
Well, I understand that, but that's balanced against there are only certain types of, quote, mistakes, unquote, by judges that we are allowed to or would dream of interfering with. Hence my lord's question. And you have to say that he was not entitled to accept the evidence or was not entitled to read it in the way that he did.
Maybe if I can take your lordships to the grounds of appeal themselves.
Mm-hmm.
And see. Oh, my learned junior. I'm so sorry, my Lord Justice Males, but in fact, my learned junior points out it is in the skeleton.
Right. Well, if you didn't know that, I don't feel so bad about it.
We both made a mistake, my Lord. It's at page 31, and I'm obliged to Mr. Hannah. At subparagraph E, and the reason that my Lord may not have latched onto it with perhaps the clarity that the skeleton perhaps ought to have written is that the issues identified there, we see CTO, and of course no drawing identifies CTO. But CTO, as the footnote 16 makes clear, Cameron Taylor Bedford, the designer named on the drawings, was the previous name of the company, now named as CT1.
Yes, that falls some way short of a submission that there was or may have been a belief that consulting is legally liable for the negligence of one.
I understand what your lordship says. My point is a slightly different point, which is that is what I'm seeking to do by identifying the test in insight is to put the test in insight in the context of this case. And to say, if we look at the evidence in this case, is it such as to allow the court to conclude that the mistake is one of identity, or one of name? And that's the reason why I'm putting it in the way in which I do. And just for the court's note, the grounds of appeal with which we're concerned are at paragraph 4, pages 12 and 13 of the appeal of the core bundle.
Yeah. So is there anything else on the second point which you dealt with first, namely by reference to insight?
No, my lord.
Right, okay, so that's, just get my note. Right, so submission 2 dealt with, and so you're now going to what you said you'd come back to.
Yes, my lord, yes.
Which is submission 1, which is
Adelson.
Adelson.
Yes, which is, we're back into tab 4 of this abundant authorities. And the test, it must be clear that he must be in a position to demonstrate that had the mistake not been named, the new party would have been named in the pleading. Now, as I identified earlier, the relevant date for the application of that test is the date upon which the mistake is made. Namely, the date upon which CTC Consulting is identified on the claim form. So the test is, the evidence has to establish that had the mistake not been made, i.e. the identification of consulting, one, or Bedford, would have been named in the pleading. Now, one can see the way that this is approached by the court in Adelson. And we need to turn into Adelson at 351. At paragraph 67, under the heading The Nature of the Mistake. Common ground that the allegation, the particulars of claim, the second claimant was a trading company, was erroneous. The judge concluded that this error reflected a mistaken belief that the second claimant was a trading company, and that if this mistake had not been made, it is probable that the second, third and fourth claimants would all have been joined as claimants. This conclusion was founded on no more than the fact of the error in the original pleading. No evidence was adduced as to how the error came to be made, or what would have been done had the error not been made. And then there's a reference to the pre-action correspondence, which we're not concerned with here. And then over the page at 352, Mr. Warby, that was counsel for the defendants, challenged the claimant's assertion that the second claimant had been named in the particulars of claim in mistake for the third and fourth claimants. He submitted that there was no basis on which the court could find that there was a kind of mistake that fell within CPR 19.5. It was possible, indeed likely, that a deliberate strategic decision had been taken to select the second claimant as the appropriate party. That decision might have been mistaken, but such a mistake would not fall within the ambit of the rule. Mr. Price submitted that the fact that a mistake had been made was evident from the particulars of claim. He further submitted a broad meaning should be given to mistake, relying on Morganest. And then at 69, we've explained why Morganest should not be followed. If those responsible for the particulars of claim had knowledge of the corporate structure of the Las Vegas Sands Group, that was the group in which the second, third and fourth defendants were all part, and of the part played by each company in the group activities, and deliberately decided to sue in the name of the second claimant alone, the fact that this decision may have been mistaken will not bring the case within 19.5. And then this important sentence. To do this, the claimants must establish that those responsible for the particulars of claim were under a mistake as to the group structure or the roles played by the members of the group, and, but for that mistake, would have included as claimants the third and fourth claimants. This is the very minimum that they need to achieve if they are to have an arguable case that a mistake of name within the Sardinia-Celsus test occurred. Paragraph 70, the particulars of claim were settled by junior counsel who no longer represents the claimants. Declaration of truth was signed by Salins, the solicitors. No evidence has been adduced to show that there was a mistake on the part of Salins or counsel as to the roles played by the relevant claimant companies, but for which mistake the third and fourth claimants would have been joined in the action. Now, again, those paragraphs, those passages emphasising the importance of causation here. The mistake has led to company A being identified as opposed to company B. Pausing and asking oneself at this point, how could my learned friends, solicitors, have identified one as the contracting party as opposed to the party they did identify when the contract was missing? They couldn't find the contract. This was not a case of the sort that we see, for example, in TRW, a recent decision of Mr. Justice Fraser on mistake, in which he talks about the solicitor being able to select the correct party if he'd gone back to look at the lease. There was nothing here for the solicitor to look at. Because the contract could not be found.
Yeah.
And in my respectful submission, that means that the but-for test identified in Adelson here simply cannot be satisfied.
Yeah.
So taking all of the evidence in the round, the answer to the question posed by 3A can the court be satisfied that the new party is to be substituted for a party who was named in the claim form in mistake for the new party? The evidence does not allow you to be satisfied of that fact.
It doesn't have to be a reasonable mistake, does it, to satisfy 19.5, just a mistake?
It just has to be a mistake, my lord, yes.
So, similar question to what I asked you before, but in relation to this issue, you have to say, don't you, that the judge was not entitled to accept the evidence at paragraph 327 of Mr. Ajetu, where he says, this is what I believed, and if I had known the true position, I would have done it differently.
Not in relation to my point that I've just made on Adelson, no. My point on the Adelson causation point is he couldn't have done it differently because he didn't have the contract. They accepted they didn't have the contract.
Well, that's why I asked you about whether it had to be a reasonable mistake, but he says he had been informed that consulting was the company that had been engaged. It's true, he doesn't go precisely into who, how, where, when informed in that, but that's what he says his belief was.
But
So
for
that has
naming
to be-
consulting, who would he have named at that point?
Sorry, I missed what you said.
But for naming consulting at the point in time that he joins. So on the 17th of March, when consulting is added, who would he have named?
The
And on what
engineers who did
basis?
the engineers who did the work, which he thought was consulting.
But on what basis was that? Well, if the engineers who did the work were thought to be consulting, that is an error of identity and not an error of name. My lords, my lady, unless I can assist you any further.
I've just got one point. We don't need to trouble ourselves because it's not raised in the grounds of appeal, is this right, with the last element of the judge's judgment, which he spends some time on, which is the exercise of discretion.
No, absolutely. The exercise of discretion point before the judge was argued on the basis of the arbitration clause.
But that's
not for. That's not before your lordship.
No. Well, that's another reason why the appeal was always going to take less time, because that point seemed to take up certainly takes up quite a large part of the second half of the judgment.
It does, my lord. Yes.
Yeah. All right. Thank you very much, Stephen. Thank you very much. Mr. Hargreaves, it's 4:05. We're very happy for you to have 10 minutes roll around the ring, if that would help you. But if you'd like to start tomorrow, as long as you're done by about 12:30, so Miss Parkin can reply, I don't think we mind.
Well, in those circumstances, I'm perfectly happy to begin my submissions tomorrow.
Fine, and you will have stopped by 12:30?
Yes.
Because I think that's a fair. Because Miss Parkin's covered a lot of the ground in terms of statements and the law, so you can skate more lightly over that. All right. Well, I think that's what we'll do. If that's all right. I started quite early this morning and spent the morning dealing with the Hague Convention. So, if I'm honest, 4:05 is a time when I'm prepared to stop. All right. Thank you both very much. 10:30. Thank you.
All right.
Yes. Yes.
Same one? Same court?
Yeah.
And can we get in that? How do you come in the other way? Which is the...
Which one?